Start. Wisdom belongs to the aged and understanding to the old, bracket open job, 12 is to 12, bracket close para. An octogenarian Christian failed before the family court, comma, Mallapuram against his children for arrears of maintenance on the ground that no law prescribes a Christian would be entitled to past maintenance stop. We thought the family court was right as there were no statutory provisions prescribing the same. But we probed many law and principles to understand the claim for maintenance stop. Is it a requirement that to claim maintenance there should be a positive law? Mark of interrogation. We find the reasons recorded here after that comma. To claim past maintenance, positive law is not a prerequisite. Para. The parties are Christians by faith. Stop. There is no statutory provision that prescribes the duty of the children to pay maintenance to the father in his old age as per the statutory law. Stop. Even under the Indian Christian Marriage Act, 1872, the grant of maintenance to the wife and children is silent. Stop. Karnataka High Court, noting the silence in the above statutory provisions, had taken the view that the court will have to strive to redress the grievances by adopting the principles of equity, natural justice and good conscience, bracket open. See the views of the Karnataka High Court in K. Kumar versus Leena, within bracket 2010, 0 AIR within bracket KAR 75, bracket open 2010 within bracket 2 HLR within bracket KAR 278, bracket close. Stop. Para. Under the Maintenance and Welfare of Parents and Senior Citizens Act, the maintenance can only be claimed prospectively after the date of application for maintenance. Similar is the provision under section 125 of the Criminal Procedure Code. Para. The law is nothing but principles that are implicit in the relationships formed privately through practices, traditions and culture. Stop. Some legal principles followed in society in past may have gotten statutory recognition through legislation. In a country where the social order is defined by the practice of the community or that of a denomination adhering to a long-standing religious norms and precepts, the court will have to recognize those norms and precepts creating such relationship in that social order. Para. In Holy Bible it is written as para, inverted comma open, honor your father and mother, inverted comma close, bracket open. This is the first commandment with a promise, bracket close, that is may go well with you and that you may live long in the land. Stop. Para, within bracket Ephesians 6 is to 2, 3, bracket close. Listen to your father who begotten you, and do not despise your mother when she is old, bracket open. Proverb 23 is to 22, bracket close. But if anyone does not provide for his relatives, and especially for members of his household, he has denied the faith and is worse than an unbeliever. Para. Timothy 5 is to 2. Para, in the Universal Declaration of Human Rights under Article 25, it was declared as follows. Para, everyone has the right to a standard of living adequate for the health and well-being of himself and of his family, including food, clothing, housing and medical care and necessary social services, and the right to secure in the event of unemployment, sickness, disability, widowhood, old age or other lack of livelihood in circumstances beyond his control. Para, under Article 41 of the Indian Constitution, though one may think that is the duty of the state to provide measures to secure the needs of senior citizens during their old age, we cannot ignore the principles in a social order creating an obligation on the children to maintain their parents during old age. It is appropriate to refer to the views of Ronald Dworkin, expressing in taking rights seriously about the judge's role in making decisions and using discretions. Para, inverted the law does not simply state what private citizens ought or ought not to. It provides what they have a duty to do or no right to do. It does not, moreover, simply advise judges and other officials about the decisions they ought to reach. It provides that they have a duty to recognize and enforce certain standards. It may be that in some cases a judge has no duty to decide either way. In this sort of case, we must be content to speak of what he ought to do.